Thanks, Nick, for the introduction. Thanks, Bill, for organising the event and inviting me over to give the plenary talk. Often I have to explain to American audiences why I'm from the University of Arkansas with an English accent. I never had to do that to an English audience. Small story. Kirk short. And thanks also for going Algeria versus Belgium and turning up after a long day, unless you're watching on your laptop, of course. Which case, let me know if anybody scores. The Civil Rights Act of 1964, this is its 50th anniversary this year, of course, signed into law on July 2nd, 1964, and was one of the most wide-ranging pieces of legislation in United States history, civil rights legislation in United States history. It tackled voter registration requirements, although admittedly with nowhere near the same tenacity as the Voting Rights Act of 1965, the following year after. It outlawed discrimination based on race, colour, religion, or national origin in a wide variety of public facilities and accommodations. It prohibited state and municipal governments from denying access to public facilities on grounds of race, colour, religion, or national origin. It encouraged school desegregation efforts, which in many places, even 10 years after the Brown v. Board of Education school desegregation decision, was still largely non-existent, by permitting the US Attorney General to file lawsuits against recalcitrant school districts. It expanded the Civil Rights Commission, created by the earlier Civil Rights Act of 1957. It prevented government agencies that practiced discrimination from receiving federal funds. It prohibited discrimination by employers on the basis of race, colour, religion, sex, or national origin. It made it easier for civil rights cases to move into the federal court system, away from the more racially biased state courts. It established a community relations service to assist in community disputes involving racial issues. And it provided penalties of up to $1,000 fine or 6 months in prison for individuals in violation of the provisions of the Act. The Act not only made it a significant contribution in its own right, but it also laid the foundation to many federal civil rights policies, legislation, and court decisions that follow. And there are 10 main provisions of the Act, and I just ran through them then, 10 main titles of the Act. 50 years later, up to today, many of the issues that the Civil Rights Act of 1964 addressed are being revisited in contemporary US politics, law, and society. This year, which also marks the 50th anniversary of the so-called Freedom Summer in Mississippi, a concerted attempt by a coalition of grassroots, regional, and national organisations to register black voters, a state voter ID law will be used that's the closest thing to a poll tax witnessed in the state since the use of the poll tax was outlawed in federal elections, again 50 years ago, by the 24th Amendment ratified in January 1964. 60 years after the Brown v. Board of Education decision, after dramatic changes in the 1970s and 1980s, US schools are today back to late 1960s segregation rates. So it's an interesting time, I think, to be thinking about anniversaries from the 60th of Brown and the 50th of the Civil Rights Act, and also the 70th of Smith v. Allwright, another important court case involving voter registration or voting rights. The invoking of the language throughout the Civil Rights Act of race, colour, religion, or national origin as markers of discrimination is relevant in the context of a new survey released by the Public Religion Institute earlier this month. It suggested that 10% of Americans today believe that business owners should be able to refuse service to black people if it violates their religious beliefs. And religion and freedom of religion is the hot topic at the moment in the courts and in American politics, as I'll elaborate more on later. These opinions about certain African Americans were uniformly scattered across the United States. In fact, interestingly, slightly lower in the South than in the Northwest and the Midwest. Younger Generation Xers, according to the survey, were more likely to agree with those sentiments than older generations. Acceptance of discrimination, if perpetrated in the name of religious freedom, the survey found, was not uncommon in American society. 15% of respondents said that it was fine for businesses to deny service to atheists. 12% said the same thing about Jews. These opinions, although a small minority, or perhaps only a small minority who are willing to openly express them, come within the context of numerous debates about the relationship between individual freedom and religious tolerance that have recently resurfaced in the United States. A number of states, for example, have sought to pass laws that would allow businesses to refuse to serve gay customers if it offends their religious beliefs of proprietors. So far, most have proved unsuccessful, although Mississippi's law passed and comes into effect on July 1st, just in a few weeks' time. Currently pending in the United States is the court case of Sebelius versus Hobby Lobby Stores Incorporated, which is a response which is eagerly anticipated almost anon in the next few weeks. The case deals with the Affordable Health Care Act's stipulation that employers must provide health care for their employees, including all forms of contraception. Hobby Lobby, an arts and crafts chain store based in Oklahoma, contends that its, quote, religious beliefs prohibit them from providing health coverage for contraceptive drugs and devices that end human life after conception. Its defense, as with anti-gay laws, invokes the Religious Freedom Restoration Act of 1993, which states that the, quote, government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. The case also speaks to the controversial Citizens United versus Federal Election Commission 2010 decision by the US Supreme Court that determined corporate personhood confers the right for corporations to be identified as individuals and thereby exercise the same constitutional rights as individuals. In the context of the Hobby Lobby case, this could mean that the court decides corporations have the right to hold religious beliefs and to have them recognised and upheld as constitutional rights. So that anticipates kind of what my paper is talking about, this shifting concept of what civil rights are and who has them between 1964 and the present day. So what does all this have to do with the Civil Rights Act of 1964? Well, I think at root, the debates about the relationship between the rights of the individual, the role of the rights of private businesses and private business owners, and the role of the federal government as an arbiter in that relationship is strikingly similar to the debates that surrounded issues related to the 1964 Civil Rights Act. The question in both instances, I think, is this that ties them together. The question of who controls commercial spaces and what rights do those involved in commercial exchanges in those spaces have. The 1964 Civil Rights Act proposed a very different answer than the one being proposed today. The Act and subsequent US Supreme Court decisions handed a large amount of regulation of those spaces and exchanges to the federal government through the Constitution's Commerce Clause that gives the federal government the right to regulate interstate commerce. Recent decades have seen Congress and the courts curtail that power considerably, narrowing the scope and reach of federal and state action in favour of the rights of private businesses and business owners. 50 years later, the indications are that the pendulum is swinging decisively away from federal regulation to an assertion that private businesses are virtually sovereign over their own commercial spaces and the commercial exchanges that take place in them. This marks a fundamental power shift that potentially has a dramatic impact on civil rights in the United States. The invocation of religious freedom as a new factor in current debates and one I'll come back to later on. But on the direct relationship between the 1964 Civil Rights Act and today, see, for example, an exchange that occurred between then Kentucky Republican senatorial candidate and Tea Party poster child Rand Paul and Liberal talk show host Rachel Maddow in May 2010 as they discussed the 50th anniversary of the student sitting movement that had challenged segregation laws at lunch counters. In the discussion, Paul seemed to question the validity of the 1964 Civil Rights Act. He conceded that he was okay with at least 9 of the 10 titles in the Act, but he balked at Title II, which, he claimed, infringed upon the rights of private business owners in dictating to them exactly who they were obliged to serve. Maddow pressed him, how about desegregating lunch counters? Were you in favour of that? Paul replied, well, what it gets into is this, is that then if you decide the restaurants are publicly owned and not privately owned, Does the owner of the restaurant own his restaurant? Or does the government own his restaurant? Paul's comments raised a storm of controversy. The Republican Party hierarchy quickly distanced itself from him, and he was forced to clarify by the party authorities that he did indeed support the 1964 Civil Rights Act and the desegregation of lunch counters, but the political damage had already been done. Unwittingly, Paul had stumbled into a long, ongoing debate which played an important role at the time of the sittings in 1960, which became part of the wider debate about the implementation of the Civil Rights Act of 1964. Examining that debate is, I think, instructive in understanding contemporary debates about the rights of individuals versus the right of private business, and why we are still having those debates 50 years later. Untangling the threads of that story from grassroots level up to Congress and the Supreme Court begins in my own backyard, in my adopted city of residence, Little Rock, Arkansas, and I use this case study sparingly, but it kind of is interesting because it threads through the grassroots level all the way through to the Supreme Court and Congress and shows how this issue kind of unwound from a tangible, concrete situation and how it got into the kind of broader dimensions and understandings of law that are at play still today. So it begins with the sit-ins in Little Rock on April 13th, 1960, when Frank James Lepper and Thomas B. Robinson, students of the historically black higher education institution Flanders Smith College, requested service at Lass's segregated downtown lunch counter on Little Rock's main street. The white store manager told Lepper and Robinson that he was not prepared to serve them, and he asked them to leave. They refused. The assistant manager then called the police, who escorted the two students from the building. The students were charged under Arkansas Act 226, passed in 1959, which prohibited, quote, any person from creating a disturbance or breach of the peace in any public place of business. In addition, and this was crucial in the case, Lepper and Robinson were charged under Arkansas Act 14, also passed in 1959, that made it, quote, unlawful for any person to refuse to leave the premises of any person when so requested by the manager or owner thereof. That is a trespass law. And the trespass law became a crucial part of this in terms of determining the relationship and ownership of the commercial space and the rights the business derived in, and the rights of these individual students. The arrest of Lepper and Robinson followed a wave of sitting protests set in motion by 4 students of North Carolina's Agricultural and Technical College in Greensboro on February 1st, 1960. The actions of those 4 students, later joined by others, eventually forced local businesses in Greensboro to count the costs of continued disruption by versus ending segregation. Many businesses decided to desegregate as a result. In March 1960, a new civil rights organisation, the Student Employment Committee, or SNCC, was founded to coordinate the sit-ins, which spread rapidly across the South. Within a year, over 100 cities had experienced sit-ins, with over 50,000 participants and over 3,000 arrests. Little Rock's first sit-ins came on March 10, 1960, followed by more demonstrations over subsequent weeks. All of the students arrested were charged under breach of the peace. They were handed fines and prison sentences as the local business community remained reluctant to meet their demands for desegregation. All of the students appealed their fines and sentences in the courts. The arrest of Lepper and Robinson on April 13th led significantly to this additional charge of trespass, which meant that they ultimately, as we'll see, were treated very differently from the breach of peace parades. Shortly before the sit-ins arrests of Lepper and Robinson in Little Rock, the NAACP, National Association for the Advancement of Coloured Peoples, Legal Defence Fund, the LDF, had discussed its legal strategy for handling this burgeoning number of sit-in cases in the courts. On March 18, 1960, LDF Director Counsel Thurgood Marshall called a conference of 62 LDF lawyers at Howard University in Washington, D.C. to discuss the cases. They considered a number of ways forwards, and it's interesting how the NAACP construed their kind of legal attack on segregating lunch counters. Firstly, sitting participants could claim a violation of the 14th Amendment's guarantee of due process of the law if they were charged with a breach of peace, without any actual evidence of a disturbance having taken place. It is just used as a ruse to arrest sitting demonstrators. Secondly, they could claim that segregation laws violated the 14th Amendment's Equal Protection Clause that said no state could, quote, deny to any person within its jurisdiction equal protection of the laws. That is, if the state was involved, they were in violation of the 14th Amendment. Since whites were being served at lunch counters, African Americans were not. Thirdly, if sitting participants were convicted of trespass in a place where segregation laws existed, this too would be a violation of the Equal Protection Clause, since the trespass laws were not being equally applied to whites, again, basically, people believed. Finally, for any sitting participant convicted on state-owned property, the 14th Amendment's Equal Protection Clause specifically prohibited states from enforcing segregation statutes. So the NAACP effectively believed that the 14th Amendment had it pretty much covered in all eventualities, or believed that it should have it covered in all eventualities. However, in the civil rights cases of 1883, the United States Supreme Court had made it explicitly clear that the Equal Protection Clause did not cover private individuals, organisations, or establishments, which were free to choose their own clientele, even if that meant discriminating on the grounds of race. So what then would happen in a case where there was no connection between state action and the conviction of sitting participants, and where the private wishes of proprietors were solely involved? Civil rights cases said the 14th Amendment doesn't apply to private businesses, private individuals. So what happens if a private business person refuses to serve an African American? Which is kind of the parallel now. The question that's in the United States immediately now is what happens if a business proprietor refuses to serve a gay person, given the laws in the books in the state. Did the owners of private establishments still have the right to discriminate, as the 1883 civil rights cases suggested the NAACP wanted? LDF lawyers looked to a more recent case of Shelley versus Kramer in 1948 as a precedent for extending the 14th Amendment's Equal Protection Clause to private discrimination, and that's essentially what the NAACP fought for, this idea of extending the 14th Amendment to cover private businesses and private organisations. If you do that, that kind of gets rid of all the ambiguities. In the Shelley case, which was about restricted covenants in property contracts used to prevent sales of homes to African Americans, so you could put a clause in the contract that says you cannot sell this home to an African American, put it in the private contract, and that perpetuates discrimination. The US Supreme Court in 1948 said that's not allowed anymore. Shelley versus Kramer says that you can't use those because the state ultimately has to enforce those covenants, and that's state action, and that's not allowed through the 14th Amendment. And this new kind of turn in Shelley had allowed a very wide interpretation of what state action actually meant. As LDF lawyer Jack Greenberg put it, and I think this is a great quote, and this quote could, from 50 years ago, could equally be kind of inserted into jurisprudence today. Greenberg asked, since private decisions cannot be enforced without an ultimate, although sometimes only implicit, state sanction, is everything we do state action? Do all personal decisions present constitutional questions? Where should the courts draw the line? It was these questions that the US Supreme Court confronted in the trickle of sitting cases that arrived in its 1960-61 terms. In these cases, the courts consistently reversed convictions. At the same time, crucially, the Supreme Court refused to extend the 14th Amendment's Equal Protection Clause to include instances of private discrimination, as NAACP lawyers had wanted it to. Doing that, the court believed, would be tantamount to ordering private businesses to desegregate, and that would be on the scope of their power. Instead, the court majority sought to sidestep the Equal Protection Clause and devised other ways to reverse sitting convictions. In the case of Boynton v. Virginia in 1960, for example, the court used the Interstate Commerce Act to reverse the conviction of Bruce Boynton, an African-American Howard University law student arrested for refusing to leave the white section of a bus terminal restaurant in Richmond, Virginia in December 1958. In the case of Garner versus Louisiana, convictions of state protesters in sitting protesters in Baton Rouge were reversed on the grounds that there was insufficient evidence that their actions had caused a breach of the peace under state trespass laws. In the 1962 court term, more sitting cases arrived. The first group of cases, sitting participants had their convictions overturned on the basis that local ordinances required segregation in restaurants, demonstrating, the court said, a clear link between state action and racial discrimination. In the second group of cases, Sitting convictions were overturned because city officials had made it clear prior to the sittings that participants would be prosecuted. Again, they said the chain of connection to state action is there. In another case, the court majority looked to stretch the idea of state action even further. Those justices supporting a liberal interpretation of state action relied on the fact that it was a deputised county sheriff who also happened to work as a security guard for the company where the sittings had taken place, and who had asked the students to leave to overturn their conviction. So it wasn't even the state agent who had asked them to leave. It was the state agent acting as a private security guard in the place, and they said, well, that's close enough. That's still up to the state. It's getting more and more tenuous, that gap between state action and what is the private action. The court's 1962 term came to an end with the justices still dismissing convictions without tackling the thorny constitutional question of extending the provisions of the Equal Protection Clause. In May of 1963, the Arkansas Supreme Court, tiring the claim of the US Supreme Court's indecisiveness, handed down its own ruling in the liberal sitting cases. Chief Justice James D. Johnson, who was himself a former president of the Associated Citizens Council of Arkansas, an organisation dedicated to resisting school desegregation, ordered the convictions of all students arrested under Act 226, the breach of the peace students, to be overturned. The court accepted local African American attorney Wiley Granton's argument that there was insufficient evidence to support those convictions. However, at the same time, the court said that Lupper and Robinson's convictions should be upheld because of the trespass, which they said was a different thing altogether. The court ruled that the trespass law did not violate the 14th Amendment rights of the students, since, as the court said, quote, by its terms and on its face, the statute applies to all who refuse to leave, and it is not restricted to Negroes. There is nothing uncertain, indefinite, or vague about Act 14. It prohibits trespass. So in effect, they said that the trespass law is a kind of colourblind law. It applies to everyone, it's not discriminatory, it can be used neutrally, and it was used properly. In this case, you can turn away whoever you want to, as long as you don't mention race at the back. In its 1963 term, the US Supreme Court found it increasingly difficult to extend the parameters of what state action meant. And the Supreme Court went through a variety of contortions to try and keep this state action to the foreground. But by 1963, it became clear that not all these cases could be covered by state action. And they were kind of at the end of their jurisprudence to try and uphold the sitting cases, which they wanted to do. They wanted to make sure that the sitting cases which they were legal right were not prosecuted, but it was getting more and more difficult legally to actually uphold that. And that's where, importantly, the 1964 Civil Rights Act came in. Just as the court appeared stretched the limits of its judicial authority, developments in the US Congress intervened. On July 2nd, Congress passed the 1964 Civil Rights Act that, among other measures, outlawed segregation in public facilities and accommodations. Congress, however, was still ambiguous about the question of state action, and it went through all kinds of contortions of the Act. Rather than just say private businesses are also covered, it had to try and find a way to say that without saying that. Title 2 of the Act, Section 201A, stated that, quote, all persons shall be entitled to the full and equal enjoyment of the goods, services, facilities, and privileges, advantages, and accommodations of any public accommodation as defined in this section, without discrimination or segregation on the ground of race, colour, religion, or national origin. It went on in Section 201B to list a number of places covered by the Act, and it defined, quote, public accommodation within this meaning of this title as if its operation affect commerce, or discrimination or segregation is supported by state action. Again, the key is state action. But what exactly constituted state action, which is the thing the courts have been trying to figure out for themselves. Congress said in the 64 Civil Rights Act that it meant, quote, if such discrimination or segregation, one, is carried on under colour of any law, statute, ordinance, or regulation, or two, is carried on under colour of any custom or usage required or enforced by officials of the state or a political subdivision thereof, or three, is required by action of the state or political subdivision thereof. Upon the Supreme Court's lead, this constituted a very liberal reading of what state action meant. In Section 201E, the Act addressed private property rights. What is private property? By saying that, quote, the provisions of this title shall not apply to a private club or other establishment not in fact open to the public. So they covered this, they refused to break this barrier, this distinction of what private is still private and still out of the range of this Act. Except to the extent that the facilities of such an establishment are made available to the customers or patrons of the establishment within the scope of subsection B. What does all that mean? In essence, the only establishments that were not covered by the Act were those that did not require state action to uphold segregation laws or enforce discrimination, and those that did not rely on interstate commerce. In practice, under the terms of the way it was written, it was difficult to see any single business that could get around it. So rather than say, this extends to private businesses, they kind of narrowed the scope of state action into state commerce so narrowly it was difficult for any business to say we are in fact a private business. So it just defined what private business was, what a public space was, in a very different and constricted and narrow way, rather than kind of breaking that barrier altogether. The other cases that came through the courts of Leper and Robinson, consolidated with the South Carolina case of Ham v. City of Rock Hill, were the first to be heard by the United States Supreme Court after the passage of the 1964 Civil Rights Act. The legislation introduced another pressing constitutional question. Could the Civil Rights Act be applied retrospectively and thereby used to quash all the convictions of those charged with defying the segregation laws that Congress had now made illegal? That is, you had 3,000 people who had already been arrested in the sit-ins, and Congress now had made all offences which they'd been arrested for illegal. But they were still going through the court, so what could you do with people who'd broken the law before you changed the law? The court employed the legal doctrine of abatement to rule that it could do that. The doctrine of abatement allowed the setting aside of pending judgments due to a change in the law that rendered invalid the laws under which the original charges were brought. Although the doctrine had never been used before to annul state criminal convictions because of a change in federal statutes, it expeditiously achieved what the court had leaned towards throughout the sitting cases in the reversal of all convictions. So over 3,000 sitting cases pending through the courts were summarily dismissed as a result of that ruling. So if you ever wondered what did happen to all those people in the sittings who got arrested after 1960 when the spotlight goes away, ultimately they all had their cases abated by the Supreme Court decision and all had their cases quashed and released. In two landmark rulings after the 1964 Civil Rights Act, the Supreme Court upheld congressional power to pass desegregation law that applied to accommodations involved in interstate commerce, rather than relying on the provisions of the 14th Amendment's Equal Protection Clause. This marked a new direction in law and in policy that had been encouraged by the Kennedy and Johnson presidential administrations. So it moved away from the NAACP's focus on the 14th Amendment and moved to a focus on interstate commerce and how that was applied. Two key rulings in Heart of Atlanta Motel versus United States. The court ruled that a motel was obliged to accommodate African American patrons since the failure to do so would interfere with interstate commerce. That is, the motel dealt with interstate traffic, therefore it came under the interstate commerce laws, therefore they were going to outlaw discrimination. In Katzenbach versus McClellan, the court ruled that Ollie's Barbecue in Birmingham, Alabama, could not refuse to serve African American customers since the food cooked in the restaurant originated from out of state. So the food comes from out of state, therefore it's interstate commerce, therefore we can say whether you discriminate against customers or not, in many respects. So that gives a very large reach to the federal government, and that is the way that the court interprets the law into regulating private businesses and the interactions of commerce which takes place there. However, the failure of the court to address the extent of the Equal Protection Clause, which the NAACP had wanted when it had the opportunity, and many believe the will to do so, has been lamented by legal scholars ever since, not least because of the rulings of more recent and more conservative courts. In 2000, for example, the court narrowed the scope of both the Commerce Clause and state action considerably. In United States versus Morrison, the court invalidated a section of the Violence Against Women Act of 1994 that gave victims of gender-motivated violence the right to sue their attackers in federal court. The court relied on an earlier ruling in the United States v. Lopez, 1995, which limited the Commerce Clause only to activities that had direct economic consequences. It also revisited the 1883 civil rights cases to again limit the definition of state action in favour of private individuals, moving in precisely the opposite direction of the court in the sitting cases. So what's been wrong in the courts is that that whole state action movement coming back and being reinterpreted again in favour of private businesses rather than individuals. Thus, while the immediate issues of segregation and racial discrimination that the sit-ins addressed over 50 years ago have now become a sign of the past, the fundamental questions of law that they raised remain contested and unresolved today as they were then. This brings us back to our friend Rand Paul. It's important to note that his comments on the Rachel Maddow show about the sit-ins were not necessarily out of step with the sentiments of the Republican Party and their aims, but rather in the framing of the argument. The idea that the 1964 Civil Rights Act infringed the rights of private businesses was misplaced. The Supreme Court in the 1960s had precisely avoided tackling that question, and contemporary political circumstances in 2010 did not warrant revisiting that complicated constitutional issue. Though ideologically coherent, Paul's argument was not politically expedient. The way to roll back the 1964 Civil Rights Act, conservatives appeared to then have concluded, was to revisit the extent and scope of state action under the Commerce Clause and to narrow them rather than widen them as the court did in the 1960s. This meant that instead of arguing that private businesses should have a right to refuse African American service, the argument against government interference was foregrounded because it was more palatable, more on message, and on its face at least, less colourblind, even though it was ultimately capable of achieving exactly the same outcomes that Rand Paul falteringly tried to advance. However, more recent developments have suggested that this more subtle way to uphold the rights of private businesses over individual customers and employees is increasingly being abandoned in favour of a more forthright and radical expression of business rights under the name of religious freedom. And I'd argue that the religious freedom arguments currently being injected into the debate are a very thin smokescreen indeed by outright prejudice. Earlier this year I wrote a piece for George Mason University's History News Network blog that responded to the Arizona anti-gay bill. In it I observed, to quote myself, many Southerners believe that racial segregation was biblically sanctioned and could have argued the same line. Indeed, if the courts had upheld Arizona's State Bill 1062, there seems to be little reason why the South could not have revived Jim Crow laws, segregation laws, prohibiting the service of African Americans on religious grounds. At the time, I thought I was employing hyperbole for effect, but it turns out, as the recent Public Religion Research Institute survey says, I quote at the beginning of this talk, a good 10% of Americans already agree with me that yes, you should be able to use that to not serve African American customers on grounds of religious freedom. The indications are that the Supreme Court is similarly changing its mind on religious arguments. Take, for example, Justice Antonin Scalia's key vote in the court. In 1990, Scalia wrote a majority opinion issuing a strong dissent against the wanton free exercise of religion in a case that denied PO using Native Americans exemption in drug use laws. Scalia's opinion demanded, quote, what principle of law or logic can be brought to bear to contradict a believer's assertion that a particular act is central to his personal faith? Scalia insisted that neutral laws must hold sway, or else every religious objective will become, in Scalia's words, a law unto himself. That is, if you say, it's against my religious beliefs to do this, then you can just say that and you can get away with it. If that's the kind of extent, if you uphold the religious rights of everybody, you just say, this is my religious belief, I'm exempted in the First Amendment, I can do whatever I like. Indeed, it was this case in which Scalia offered this dissent, offered the majority opinion, Employment Provision versus Smith in 1990, that prompted Congress to pass the Religious Freedom Restoration Act of 1993 in the first place. Yet in the more recent case of Sebelius versus Hobby Lobby, currently pending through the courts, Scalia seems to have changed his mind, and now his questioning in arguments has indicated a change of heart in seemingly upholding the very principles of religious freedom that he had earlier rejected. A recent book on Scalia suggests that this is kind of cynical in the sense that it reflects, the current case reflects Scalia's own Catholic influenced beliefs, whereas the earlier Native American case didn't. Either way, the decision in the Hobby Lobby case promises to be a landmark ruling in the balance between civil rights of customers and employees and the religious rights of owners and employers. Effectively, it could mark a shift from the primacy of upholding the civil rights of individuals 50 years ago to the primacy of upholding the civil rights of private businesses and corporations today, that that is, the shift in emphasis has taken place from the civil rights of individuals to the civil rights of businesses, which kind of, has precedence in earlier periods of American history that suggests a cyclical return back away from individual civil rights and towards the rights of corporations and businesses. But if legal and political decisions seem to be swaying decisively away from the direction they were in the mid-1960s, then there's another lesson from 50 years ago that offers a different take on how things currently may unfold. Again, to quote from the piece earlier this year that I wrote on the History Use Network, to quote myself again, Senate Bill 1062 was doomed to defeat because of earlier constitutional precedents. Firstly, the bill clearly involved state action and contravened the 14th Amendment, but other subsequent anti-gay bills, like the one in Mississippi, have kind of shifted the language around to avoid doing that. Secondly, the federal government could once again have invoked the Commerce Clause to overrule the bill. But finally, and most importantly, Arizona discovered, just as the South once had, that discrimination is, in fact, ultimately bad for business. It was the economic damage done by the citizens that caused many establishments to desegregate in the 1960s. Businesses were disrupted and images of cities were tarnished. Likewise, Arizona risked losing out on holding the NFL Super Bowl in 2015 if it had persisted in its desire to pass its anti-gay bill, and a number of big corporations successfully lobbied Governor Jan Brewer not to sign the bill into law. It was economic self-interest that killed Senate Bill 1062 in the end, just as it killed legally mandated racial discrimination in many businesses in the South 50 years ago. And of course, commerce remains a crucial part of American life today. Mississippi's attempt to impose an anti-gay bill in the state has already met with grassroots resistance, and with some store owners gladly proclaiming that gay customers are welcome to spend money at their establishments if other proprietors want to turn their dollars away. The stickers in their windows read, quote, "We don't discriminate. If you're buying, we're selling." As the fast food chicken chain Chick-fil-A discovered a couple of years ago when its president declared himself in favour of supporting the biblical definition of the family unit, bringing forth high-profile protests at and boycotts of its stores, discrimination can be very bad for business. The PR people were quickly sent in to try to undo the damage, with a spokesman borrowing from and then extending the language of the 1964 Civil Rights Act. While declaring that, quote, "Our intent is not to support political or social agendas," Steve Robinson, Executive Vice President for Marketing at Chick-fil-A, said that it was in the company's culture to, quote, "treat every person with honour, dignity and respect, regardless of their belief, race, creed, sexual orientation or gender." So now you have the corporations quoting the Civil Rights Act to sort of show that they're not discriminating against anyone. So, perhaps in the current struggle over civil rights, it may be that only the vagaries of the marketplace are left in the absence of seeming current political and judicial support and ambivalence of the matter, or hostility towards the matter. The free market may be the only thing left in the way to uphold customer and employee quality. I'll finish there. Thank you.
Thank you. Hi, everybody. Thank you, Professor Kirk. It's a real pleasure for me to be here and to actually respond to you. It's over a decade that my supervisor and mentor, Professor John Howard, introduced your work to me and our undergraduate class. I've used it in my PhD dissertation. I actually emailed you once. You did respond. Great sources in there. So this is real treat. It's a fan moment for me. To be concise, I put my stuff down on paper, but do forget the paper. So my thoughts on the 1964 Civil Rights Act. It's a key piece of legislation, a key accomplishment of the Second Reconstruction. 1964 Act covered a wide range of subjects, 3 of which are particularly noteworthy. As we heard, it covers a vast range. 3 are used probably daily by the vast majority of Americans. 1, the Act prohibits racial discrimination as well as other forms of discrimination. in places of public accommodation. That's Title II, the focus of this paper. It prohibits racial discrimination across a broad area of employment. There's Title VII, and the Act enjoins the federal government to withhold federal funding from entities that engage in unlawful racial discrimination as well as other forms of discrimination. Title VI. Quick overview. The 1964 Civil Rights Act represents, for me, one of the greatest triumphs of the Civil Rights Revolution. Why? In terms of the way this act actually subjected large areas of social activity to anti-discrimination laws. In other words, social activities that previously were not regulated by the federal government. That's what the act does. And that is a tremendous achievement that really can't be underestimated. The reason why this act, for me, also raises the spectre of defeat, was actually raised in Professor Kirk's paper, is that the civil rights activists themselves, so this is including the NAACP and other individuals, grassroots individuals, they were unable to compel the Supreme Court to recognize that individuals have a constitutional right, not simply a statutory right, but a constitutional right to be free from racial discrimination in public accommodations. Or putting it somewhat differently, that those engaging in discrimination have no right to claim government assistance, effectuating their racial prejudices. And so even as we celebrate or we memorialize, whatever words you may use, we acknowledge the passing of the 1964 Civil Rights Act, it must be remembered, and for me, it needs to be centered that civil rights activists themselves understood that their demands for legislative relief was triggered because of losses in the Supreme Court. A Supreme Court that refused to declare it a constitutional right to be free from racial discrimination in public accommodations. Again, for me, remembering this Supreme Court failure, and I would use the word failure as Professor Kirk used, is as important as remembering this partial victory. Why do I say it's a partial victory? Again, as explained in Professor Kirk's paper, the primary constitutional authority for this act comes from the Commerce Clause. It is not from Section 5 of the 14th Amendment, which states equality in public life. So that's not where they went. Again, Professor Kirk mentioned that why politicians thought it best to not go with equality in public life is totally rooted in that 1883 Supreme Court decision, which invalidated a public accommodation provision in the then 1875 Civil Rights Act. So politicians want to avoid this, and they go for the safer bet, which is the Commerce Clause. So, as the paper reveals, there's many reasons why this is relevant, that politicians go for this safe bet. For me, this also brings up that historical issue of candor, of racial candor. We hear it over and over in the rhetoric. When is America going to have an honest debate about race? All the time. It came out in the presidential election, 2008. You'll remember candidate at that point, Barack Obama, giving his A More Perfect Union speech, and commentators hailing that this is the beginning of the honest debate. It was not the beginning of the honest debate. Today, we see that playing out in affirmative action cases. There, the principal justification for affirmative action in higher education is diversity. That is what's brought up in the Supreme Court. We're all too familiar with that kind of language. Also here in this country, in education, is to push for It's not about rectifying past injustices. For the Supreme Court, it's not about rectifying past injustices. It's not even about integration. That principal justification currently in the Supreme Court is diversity. Of course, I support diversity. I'm even happy to say that, yes, diversity works, and the rationale for this pedagogical theory is that there are better learning outcomes if there's diversity. Nothing against that. I actually agree. But is that honest? That's my question. Can social justice correctives be enacted by Congress or the Supreme Court if there isn't a degree of honesty when it actually comes to race relation law? So, just to be more specific, what my question for Professor Kirk would be, is it the responsibility of Congress or the Supreme Court to make moral judgments? And by that I mean to be honest about rectifying racial injustices, even if it is contentious? Or is the responsibility simply to get the job done, even if that actually endangers social justice, or means we can't actually push something through? For instance, as we know, the 1964 Act does ban racial discrimination in public accommodations. It did the job. But its justification is basically that it's bad for the economy. So in short, does the end justify the means? Thank you.
Thank you, Althea. Fantastic question. So you in there, and then we'll open up for John and then you guys.
Well, thanks very much. I suppose we are celebrating the enactment of the Civil Rights Act of 1964, imperfect though it is, and despite those imperfections, it does merit celebration. It's difficult for us now to imagine what America would have been like without the enactment of that legislation. The 1964 legislation, imperfectly, is the foundation of modern America. What we understand as being modern about America today, much of that understanding comes from the 64 Act. And what I'd like to focus my remarks on is how remarkable it was that this piece of legislation was enacted by an institution, Congress, that had hardly distinguished itself in the field of civil rights, that had effectively retreated from civil rights in the mid-1870s, refused to engage with civil rights even to the point in the 1930s that the NAACP could not get Congress to enact an anti-lynching bill. So, you know, the 64 Civil Rights Act placed in that kind of context is remarkable. And I think what's even more remarkable about it, yes, we can pay tribute to, without the grassroots activism of the civil rights movement, there would have been no Civil Rights Act. It was not white politicians acting out of the goodness of their heart. They were forced into it. John F. Kennedy in 1963, in his address to the nation, June 11th, 1963, makes civil rights a moral imperative. When Kennedy is assassinated, Lyndon B. Johnson declares, "Let us continue," and declares that the enactment of a civil rights bill should be the greatest testimony to John F. Kennedy's legacy. But in Congress, votes count for everything. And part of the problem was that it had to go through the Senate, where Southern Democrats were powerful in the committee system, but not powerful in terms of numbers. And it all depended whether a Republican bloc in the Senate would swing to the Democrats in support of civil rights or whether they would make common cause with the Southern Democrats, as they had largely done in forming a conservative bipartisan coalition in Congress in the late 1930s, and had continued that through until the 1960s. And it is largely because the Senate Republicans swung with the Democrats that legislation was enacted. There was only 33 Republicans in the Senate in 1964. 27 of the 33 voted for the legislation. So I think we should remember the Republican Party of today and the Republican Party of the 1960s were somewhat different animals. The main opposition to the bill came from the Southern Democrats, and of course Southern Democrats in the old lily-white sense of the term no longer exist. They've all become Southern Republicans in today's polity. So, you know, this was a remarkable turnaround, and in reality, one of the most, I hesitate to use the word radical because the context that we've heard, it was not radical, but I suggest that the bill was radical in terms of the moment in time that it was enacted, and in terms of what was possible. And we should remember that Title VII, we've heard a lot about public accommodation and discrimination in public accommodation. Title VII also includes prohibition against discrimination in employment, and uses a whole lot of categories: race, colour, religion, sex, national origin. Now, the inclusion of gender in there, sex in there, is quite significant, because who put it in there? Not the Liberal Democrats, not the Republicans, but the Southern Democrats, specifically the racist, virulently racist chairman of the Rules Committee, Howard Smith of Virginia. Now, did Howard Smith wake up one morning and said, by God, if blacks are going to get anti-discrimination rights, women are going to get it? No. Howard Smith put it in to poison the bill in an effort to, they said, oh, well, they'll never give these rights to women. So we'll include it in the bill and make sure they don't give it to anybody. But such was the moment that the bill did include prohibitions against prohibited discrimination by employers on grounds of sex. So, you know, there were all kinds of parliamentary manoeuvres used to block it. The Southerners in the Senate attempted to filibuster the bill out of existence. In the debate, the record was broken for the longest speech ever given in the Senate, and I think it was 26 hours by Strom Thurmond of South Carolina. You know, the parliamentary manoeuvres against the bill were immense. The bill was enacted, and America became a different place. America became a better place. It didn't become as good a place as it could have been, for reasons that we've heard. And what is unfortunate is that the Supreme Court, which had done more than any other institution of government to advance the cause of civil rights since the late 1930s, did not follow through on the possibilities of giving the widest possible interpretation to the measure as we've heard. So the Civil Rights Act of 1964, I think, deserves to be remembered. It particularly deserves to be remembered today in an age of polarization and a Republican Party that forgets that its legacy isn't simply Ronald Reagan, it's also Abraham Lincoln and the spirit of some commitment to racial equality. Whether the Republicans ever regain that spirit remains to be seen. But I still think that the '64 Civil Rights Act deserves recognition of the remarkable piece of legislation, a remarkable but flawed one. But what else can you expect from the American Congress? Thank you.